When custody or parenting time is an issue in a matrimonial action or a family court proceeding, litigants, the spouses, will be told that two events may take place. The first is the appointment of an attorney for a child. And the second could be the order by the court for a custodial forensic evaluation. Now, we've talked about the AFCs in the past, the attorneys for the children, their expanded roles, how they're really now attorneys for the child, not just in the best interest of the child, but putting forth what the child wants the court to hear. Today, we're going to talk about forensic evaluations. And a forensic custodial evaluation or assessment is conducted by a mental health professional. And what it does, it tries to get into providing insight for the court as to the dynamic and the relationships, what's been happening with this family, to hopefully arrive at what is in the best interest for all. The forensic evaluation will be ordered by a court, but it could be sought by anyone. The litigants, the attorneys, the attorney for the child, a therapist, anyone can make an application to get an evaluation. Now, for an evaluation to take place, something must be going on. The evaluator will be looking into certain things, such as domestic violence, substance abuse, mental health issues, perhaps special needs of the children, a parent relocating. That is a big issue for an evaluator to deal with. And the most important of all, again, parental alienation. These evaluators must have experience dealing with families, and they typically can be a psychiatrist, a psychologist, a licensed clinical social worker, a therapist. As long as they have experience in dealing with evaluations, they can be appointed. And they typically will be encouraged to use whatever resource they need to put together a report. For example, interviewing the parents, interviewing the children. They may conduct psychological examinations. They definitely will visit the home. They will also reach out to family, friends, teachers, anyone who has experience in the relationship between the parties here. And they will review documents, public health records, if they have the authority to do so. So, I've spoken before about parental alienation, and evaluators are keen. They have tremendous feeling for and looking for parental alienation. Again, when a parent is using damning information and manipulating the relationship that the other parent has with the child. If the evaluator feels that that's happening, it will be put into a report. And it is an important point to remember that if it goes into a report and a court is going to look at it, it can be a serious factor as to how the court is going to deal with custody for these parties. So, the evaluator prepares the report. At the end of the day, he has all or she has all the information they need. A report is prepared. How that gets submitted into evidence is for another day. It is complicated, it's for attorneys. It is for how the report is going to be offered into evidence, reviewed by the court, and spoken about by the therapist. What is important for us today is to remember this, is that that report will generally not be allowed to be given to the parents. It could be summarized by the attorneys for the parents, it could be read to the parents, but the court is not going to allow the parents to review that report. And why? The main reasons: there could be information submitted by children in that report that the court doesn't want the parents to necessarily see, and because they're afraid of two things. One, that a parent's going to manipulate the child in the future about these interactions. And worse, and more importantly, that they're going to punish or discipline the child for something they could have said in that report. So, if you're involved in one of these situations, you're involved in a custody proceeding, and an evaluation is going to be ordered, and you're going to be a part of that, some important tips to remember. Number one, meet with your advisor. Speak to your attorney. Be prepared for what is about to take place. Secondly, be totally candid. Okay, be honest. Do not get caught in a lie. That will go into a report and will not help your situation. You could talk about your strengths. You could talk about even your weaknesses. It's important to be candid, and it's always important to talk about the best interests of the child. Two things you can never do. One, coach the children as to what to say, and two, speak only negatively about the other parent. That you cannot do. You can point out how it is in the children's best interest for them to be with you and your strengths compared to the other parent. But speaking only negatively about another parent will never work and will be actually used against you. Two final points on these evaluations. The first, be prepared if you're in the middle of an evaluation that at any time Someone from ACS, Child Protective Services, the court, the evaluator, the attorney for the child may make a surprise visit to your house. Be prepared. Speak to an advisor about that, your attorney about that. Do not be caught off guard. And my last point here is, while I am a tremendous proponent of these evaluations, and they provide insight for the courts and the litigants and attorneys as to what's happening and what might be best for the children down the road, there is a small percentage of litigants, of spouses, of attorneys, and attorneys for the children that unnecessarily ask for these evaluations. And in my opinion, to put a child in an evaluation where they're going to be asked questions and maybe pitted against the other, just to foster one's agenda or one's needs, is one of the biggest tragedies that can happen in a matrimonial event. Don't let that happen to you.